So, thank you very much for inviting me. I should apologize for the absence of my co-author, Edouard Lemoalle, who is not available this morning due to professional obligations. So, the topic is company law and the pursuit of the common good. What is the contribution of company law to the common good? We told about company law in the international and more precisely English context. This means corporate law in the American context or droit des sociétés in the French one. If we consider the current textbooks in company law, we should assume that this contribution is very limited, except if we extend company law to the doctrine of corporate social responsibility, of course. The key idea of this paper is to consider the contribution, the current contribution, the possible contribution, and the historical contribution of company law to the common good. And we will base our reasoning on a goal-based approach. The paper will examine the role of the concept of common good in corporate law in both in the theoretical debate and in the legal reasoning. We will investigate ways in which the public interest could, but for the main part does not, figure in the company law doctrine. We will address this issue at two different levels. The first part will analyze to what extent company law is likely to contribute to the common good, that is to say, the common good as a goal of the company law. And the second part will investigate how the common good can be incorporated into the legal purposes and interests that the company, the shareholders, and the management have to serve, that is to say, the common good as a goal in the company law. Do or did the lawmakers pay attention to the common good when they set up company law? We will see that concern related to common good have been taken into account historically both in the French and in the American company laws, but there was a move from that point to a new division based on a distinction between, on the one hand, company law, and on the other hand, public regulation. In the new dominant legal framework, common good appears mostly to be a goal for public regulation and doesn't count any longer as such in company law. Analyzing the goals of law means identifying the targets of public policies, that is to say, the concrete results they intend to achieve and the way such expected results are foreseen in norms. How companies serve the public interest? From the conventional neoclassical perspective, the answer is hardly at all. Companies are vehicles for the pursuit of private goals, but even if investors' protection consideration have become paramount in the end of history of corporate law, they were certainly not as important in the beginning of history. If we take, for instance, the French case, we see that until 1867, the equivalent of public limited company, Société Anonyme, could only be formed upon the express authorization of an administrative body, the Conseil d'État, and need a decree signed by the emperor. The process for obtaining a corporate charter was both protracted and uncertain. The motives of French Conseil d'État in regulating corporations in the 19th century remain subject to speculation, but we can see that the Conseil d'État stressed that Société Anonyme should be reserved to large enterprises of public utility and could not engage in more than one line in business. Charles Friedman, for instance, describes the resistance to chartering of corporations enabling multiple operations of a diverse nature, such as retail trading company. Likewise, early insurance companies, for instance, could only insure against one type of risk. These restrictions in the 19th century company law might also have served a sort of common good, namely they prevent concentrations of power that were independent of the state. So the fear was to have little states within the states, or in French it's société à l'intérieur de la grande société, corporations within the big society. And in that case, we see that the common good is specifically related to consumers' interests and to the national economic interest. In decline since 1850s, the public nature of French company law became to an end with the adoption of the General Incorporation Statute in 1867, which allowed firms to incorporate without the need to obtain special regulatory charters. However, the interest of the French state as a participant in corporation have impinged on the legal regime applicable to companies. An evidence is the institutional orientation of France's company law towards the interest of the company. It's a point we will, on which we will come back later. Now we can see what is about in the American context, the role of public interest in the US company law. Adam Smith, for instance, admittedly an early critic to business corporations, identified two main shortcomings in this organizational form. The first was monopoly, and the second one, agency costs. It is clear today that the concerns about internal agency costs, conflict of interest between shareholders and the management, or conflict between controlling shareholders and minority shareholders, dominate corporate law and policy. But in the late 18th century and early 19th century, the main economic evil linked to corporate firm was not managerial misconduct leading to minority expropriation, but monopoly. And at that time, corporate law served also, and perhaps primarily, to mitigate the main economic concerns of that time, that is to say, monopoly. The goal was to protect consumers rather than protect investors. Ovenkamp, for instance, has highlighted that what turned out to be powerful antitrust provisions in early corporate charters, from holding shares in other corporations, from engaging in activities not expressly contemplated by the charter, these restrictions led to many firms to adopt not the form of corporation, but the form of trust. And that was the original point of the antitrust law and antitrust policy. And a majority of other forms of regulation in the 19th century, including pricing schemes for public utilities, for instance, also took place via corporate charters. So corporate law was used at that time as a very powerful tool to prevent public misconduct and issues. By the late 19th century, legal rules addressing antitrust, concern and utility regulation had been gradually spun off from the law of corporations, and now most American corporate law scholars believe that social policy goals should be pursued under other regulatory aids, such as environmental law, labor law, consumer protection law, rather than by diverting corporate law from its basic mission, which is now agency costs issues. So there is a sort of Tinbergen rule applied to the specific field of legal policy. We should use different legal instruments or a corpus of rules to solve different kinds of problems. Now we can go to the common good as a goal in company law. The common good or similar legal concepts such as public interest, general interest, can be considered not only as a theoretical criterion to assess the role of company law with regard to its social impact, but also as a practical legal concept within company law. So the second part of this paper will focus on a particular category of norms in company law, the teleological norms. This contribution of the company law to the pursuit of the common good is based on two requirements. Firstly, company law should be driven, at least partly, by goals. These goals should have a normative value, and the common good should be likely to be amongst these goals. Secondly, the teleological norms should be effectively enforced if these norms or derived legal standards incorporate the common good as a goal for the company and the participants. The common good is likely to be a driving internal force in company law insofar company law is based on theological norms. The concept of theological norms must be clarified. A majority of legal rules are in reality what we can call deontological norms. That is to say, they focus on behaviors in prescribing what can, should, or must not be done. On the other hand, we have norms that focus on objectives, goals, plans, and what people are supposed to target. It is important to notice that the fact that business organizations, and especially corporations, are goal-driven entities. In other words, their activity is legally oriented by the aims they have. It is a consequence of the principle of specification that implies that a private body cannot be a universal purpose entity, unlike the state, for instance, in the democratic tradition. Okay, we can go back later on that point. Company law requires from the incorporators to specify the raison d'être of the organization they want to set up as a legal person. The question is now, what are the objectives that the companies must or can follow, and where do they come from? The corporate objectives spring from statutes and are given by founders and eventually updated by the shareholders and by the directors. Thus, there is a wide variety of legal purposes, ranging from very general ones, such as public order, general business purpose, for all the companies, and very specific ones, such as the business purpose written down in each bylaws, and even a business plan, for instance, if it is legally binding. As a result, following Hans Kelson's famous model based on the pyramid of norms, we can draw a sort of a pyramid of corporate norms, and we see that there are different objectives that a company must follow, which are determined at different levels by different rule makers. This is the basic pyramid. There are, in fact, two pyramids, the static pyramid and the dynamic pyramid. This is the dynamic pyramid, that is to say the list of rule makers in the pyramid, and the static hierarchy of norms depending on the different categories of norms from the Constitution to law norms such as contractual norms, and in the company law context, bylaws. If we applied this model to the specific case of company law, we have those two different pyramids. Again, the dynamic hierarchy and the static hierarchy, with several rulemakers and several levels of definition of goals for the companies. Following the pyramid from the top to the bottom, the norms are becoming more and more less and less abstract, so the determination of companies' objectives is growing, and thus the discretion is decreasing for the people who run the business. Besides, we should notice that the teleological norms can be positive. In that case, they state what should be targeted, or negative, and they state what must not be targeted. For instance, it's an example of a negative objective. A corporation is not allowed to be set up for trafficking or terrorist projects. Positively, a specific company can choose to operate in a particular industry, or to select special category of operations that the company can have. So from this model, the question is, where is the common good located, or where can it be located? At a very high level or at a lower level? There is not only one answer to this question. Different theories can be elaborated. They depend on the general political and economic regime of the jurisdiction. For instance, if we are in a liberal state, we can guess that the principle of freedom will be the higher principle in the pyramid of norms, and the common good will have to compete or to be articulated with the principle of freedom. But if we are in a country where, for instance, the Republican tradition, the Republican philosophy is more influential, in that case, we can get that the common good principles will be the highest principle in the hierarchy of norms, and freedom principles will be accepted insofar that it could serve the common good principle. So finally, to sum up this discussion, we can make a distinction between three hypotheses. The first one is that the common good is one of the basic objectives that companies have to follow, or the common good is an objective that can complement or substitute the basic objective that the companies have to follow, that is to say, the pursuit of profit. Or, third hypothesis, the common good is incompatible with the basic objective that the companies have to follow, and so the companies have to choose be a non-profit organization or be a corporation, but necessarily a for-profit organization in that case. Quickly, I now go to the second point, the second condition. If we want that theological corporate norms have an influence on the corporation's behavior and contribute to the common good, the mere existence of a theological norm incorporating the common good that is to say hypothesis 1 and 2, is not sufficient because this norm can remain completely ineffective if it is not concretely implemented in the corporate practice and if there is no judiciary mechanism, for instance, to enforce these norms. But paradoxically, the pursuit of the common good can be a goal that is rejected in theory. It is hypothesis 3. But if there is no enforcement of this negative norm, the people who run the business will be able de facto, not de jure, but de facto, to contribute to the common good. And I will just say one word. There are three main legal standards that can help companies and corporate players to contribute to the common good that are the object of the company, but it's not the right instrument according to us. The second standard is the interest of the company, and the third standard, mostly recognized in American and English law, is the duty of loyalty of the directors and managers. And in many case law, the judge have recognized that at least partly common good objectives can be incorporated in the corporation practice. Thank you.